There were a sequence of robberies in Metro Detroit, Michigan, and Northern Ohio, and the police arrested some people, one of whom gave the phone number belonging to Mr. Carpenter. As it happened, when they requested the records from T-Mobile and Metro PCS, two cell phone companies, those records revealed that Mr. Carpenter was in the vicinity of the banks that had been robbed, and on that basis they were convicted. And now Carpenter challenges the police acquisition of that evidence, of those location records, as a Fourth Amendment violation. The word privacy doesn't actually appear in the Constitution. However, there are certain rights that we have and that we now consider to be privacy rights. The Fourth Amendment, which is at issue in this Carpenter case, is one of them, because the Fourth Amendment says that people have the right to be free from unreasonable searches and seizures without a warrant. The government can't just go into your home and ransack it in a fishing expedition to look for crimes. And as technology has developed, those protections have evolved. The Supreme Court has held that if you disclose certain data or information to a third party, like your bank, like the phone company, then that information is no longer private and no longer protected by the Fourth Amendment. The Stored Communications Act of 1986 allows phone companies to disclose records when the government provides them with specific and articulable facts showing that there are reasonable grounds to believe that the records are relevant and material to an ongoing criminal investigation. And so if the police or the FBI ask that record keeper, then they can get that without a warrant. So here, in the Carpenter case, the government simply asked the cell providers for that historical cell location data. And Mr. Carpenter says that violates the Fourth Amendment. Even if it complies with that federal statute, the government really should get a warrant. Carpenter's strongest argument is that he still has a privacy interest in the data that he provides to his cell phone company. It's not that he decides that, well, I don't care who knows about where I am based on my cell phone information. It's that he knows that in the modern world, you can't really go about your business, or at least not have a smartphone, without releasing this data to your cell phone company. And therefore, the government ought to have probable cause, ought to have a warrant in order to search it, no less than it would need a warrant to search your day planner or your phone calls. The best argument for the United States is that under the third-party doctrine, information that you reveal to third parties is in effect public. The police do not need a warrant, should not need a warrant to look at it, to seize it, to search it. This case will establish the basic law of digital privacy going forward. The amount of data that people now put on their phones is mind-boggling. Think about it. Our health records are on our phone. Our bank data records. Our text messages with our closest friends and neighbors and paramours and spouses and other romantic partners. Photographs, music, diaries, Facebook, Twitter accounts. So this little device has the potential of revolutionizing constitutional jurisprudence about privacy rights simply because we have so much private or sensitive material on it.